Hello, Heidi, welcome. Are we ready?
All right, we're good to go, Steve. Yep.
Okay, good. Thank you. Welcome, everyone. Members of the board are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest. In the appearance of conflict, are instructed to refrain from participating in any matter coming before this board with respect to which there is a conflict of interest or appearance of conflict. Welcome, everyone, to the quarterly meeting of the NC State Bar Publications Editorial Board. We're going to go into a closed session to get advice from counsel concerning some issues of controversy before the committee. So if we can do that, Catherine.
Thank you. I would ask that a member of the committee make a motion pursuant to North Carolina General Statutes 143-318.11A3 for purposes of preserving the attorney-client privilege between the public body and its counsel.
So moved.
Second.
All in favor?
Aye.
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 All right.
Aye.
Alice, did you want to respond to Camille's concern about
I did.
how this might limit the function of the journal?
Yeah. Camille, I may be wrong, but I sense there was a little bit of sort of cynicism there or irony in what you said. Yeah. And I am sensitive to that because I get the journals from bar organizations across the whole country. I have a whole stack of them in my office. And I have to say that a lot of them are just very bland. And I think we've all been really proud of our journal, the quality of the journal. Jennifer does a fantastic job. And I know this is kind of a hard thing to swallow, but it seems to me we're at an important juncture right here of two things. One is it's actually my hope that the Supreme Court will end up taking cert on one or more of these cases and will answer some of these questions that are there for us. And it's entirely possible that the court may take the position that with a sufficient disclaimer of it being the opinion of the bar itself, and with the opportunity for the presentation of opposing viewpoints, that they'll see it as more like a forum for discussion as opposed to it being, funded political speech. I don't know. That seems to me to be what the Fifth Circuit was saying, but we don't know. And what we need is guidance from the court, and we don't have that right now. The other piece of it that from my perspective is important is that I would really like for the State Bar not to be drawn into this litigation. I think there is certain organizations that are out there that are looking for integrated bars to sue over this issue, and they've stayed away from us for the reasons that Catherine articulated. And I certainly would like us to continue to maintain that for a number of reasons, but because litigation is very expensive, and it's caused us problems in the past when we had multiple expensive lawsuits going on all at the same time. So, to the extent that we can keep our powder dry and wait and see what the Supreme Court says, I think it makes a lot of sense. I have suggested to the officers that this might be a good time for the appointment of a special committee to kind of look at the future of our publications and their, the purpose that they serve, how we go about doing this. And when we have certain things we have to publish for comment, and how we do that, I think is an important question. But I guess primarily what I'm saying is that this may be disappointing to be making this decision at this juncture about this article, but the story's not over yet. I think there's more to learn. It's just we have to be patient. It's going to take a few years, I think, for an opinion to come out from the Supreme Court.
I would Thanks, Alice. No, I hear you and I hear Camille. I just think we should, it seems to me, I think a committee studying what we're publishing makes sense. As I go through some of the topics that we kind of had in the mix, I know Margaret was looking at gerrymandering articles. I don't think we should be doing that. I was going to look at electoral college. I don't think we should be doing that. I think we really need to come up with some guidance. I think, it will be a struggle to, maintain something that's engaging without commenting on policies or the social politic. I think it's becomes very much a human interest story. And we've got some good articles published in the fall and more coming that do talk about lawyers and the profession that I think are in that core competency. So I think we can work to try to keep things engaging, but I do think it's going to require a refocus, at least as to what I was kind of thinking about when I joined this board a year ago in terms of what kind of articles we want to do. And I think we probably need to revisit, we need to revisit that. For example, I've spent time reading this new pre-publication book about the history of racism at Chapel Hill that was presented and was asked to review. I'm not sure I see that fitting in our mission there, although it was suggested as a topic, and I'll talk to the author about it. I think it's an interesting and important topic, but I'm not sure I see that as one that we could safely handle. So I just think it is a little, I understand it, but it is frustrating. And I think it really does require a refocus, I guess, on where I thought some of our efforts were. And I think we need to look at that both in terms of revisiting some of the approved articles, like the Confederate Monuments article, and perhaps, revisiting the topics that we have currently out for new articles.
I think another frustration of mine is that you could say, well, let's just encourage these authors to take their articles to the non-regulatory bound, organization. But the Bar Association is not going to want to publish this because they're not going to want to piss off their paying members. And then you get to the bar associations that might be more leaning, their members leaning towards one side versus another. And so then there's no exchange of ideas. It's talking into the echo chamber. It's going to a place where everyone agrees with you. The beauty of the journal is that it goes to every lawyer in the state. And while I don't disagree at all with Catherine's analysis of the case, I'm just greatly disturbed by what I believe to be the place where lawyers gather, being a place where lawyers can't have conversations that are thought-provoking and perhaps encourage examination of ideas that might be pleasant to explore or unpleasant to explore, but it's an exploration of ideas. And so I said what I said out of certainly frustration, but also in great seriousness. I requested at the board's asking, I went and solicited an article on diversity, equity, and inclusion. And I asked for exactly what the board said. Give us an article, give us points, and give us a checklist of things to do. And the committee sat on it for a year, and people wouldn't vote on it, and people wouldn't comment on it. And my author kept asking me, what's going on with my article? I thought we wrote it exactly as you wanted. We footnoted, we made it academic. We gave you a checklist, and it's just discouraging. And so I'm happy to continue to solicit articles on my friend Josh Durham, who's doing a podcast about hot dogs and baseball. But it's disappointing to me that the place where all the lawyers in the state gather is not a place for intellectual discussion.
Are there any other comments from committee members, board members? Mark?
No, I think Camille's point is well said, and I think
Well-
but we just have to reformat. And I'm sympathetic for her work in trying to do articles. And I think many of us have been pursuing topics, perhaps without enough thought around the potential implications or what is and is not a good topic. So I think that going forward, that's something that this board really needs to focus on, I think, and provide guidance to as we come up with topics. So.
Well, I know, I mean, Mark is newer to the committee, but I can tell you for several years, we have looked at articles and solicited articles with Keller in mind and not published certain things with Keller in mind. So we've already published an article on gerrymandering and we have one in the works. We've published articles about judicial elections. We've published articles about race and diversity, and the article to which Camille was referring with the DEI checklist is coming out, or supposed to come out in this fall edition. We approved the Confederate monuments article. So at this point, I'm just sort of throwing my hands up and going, we've published a lot with Keller in mind. We have a lot approved with Keller in mind, and now I don't know what I'm supposed to be publishing or not publishing. I don't know if it's just the death penalty that is so political, and maybe Confederate monuments aren't as political, so we can go for it. But where do you draw the line of what it's super political and not super political and just kind of political and therefore publishable or not? I just feel like the waters have gotten really muddy for me today, and I'm not sure how to move forward.
Well, I can make. Oh, go ahead, Tom.
I can make the argument why the Confederate monuments article is appropriate, because it has to do with process. Because it's talking about, in general, Black people and other minorities probably walking into a courthouse seeing symbols of racism and how it might affect Blacks or other minorities being affected if they're jurors, for instance, and how that might affect their judgments and perceptions, and how it might affect Blacks and other minorities who might feel that they are walking into the lion's den and not a den of justice. So it's about process, it seems to me, in removing Confederate monuments from courthouses, as opposed to some substantive change in the law that the legislature needs to make. So I could argue, I think, easily for the Confederate monuments article. I don't see that as political. I see that as the administration of justice. But I understand your frustration. But I could also, without irony or sarcasm, say, why are we publishing any articles at all? Because the whole point of Keller in this Texas case is that it is compelled speech. That's the problem. If we've got nearly 30,000 members, and if 25,000 of us are in pretty much agreement, but 5,000 aren't, those 5,000 to some extent, and it may be small, are being compelled to publish articles with which they may not agree. So, and it's not as if these authors have no other source. They can go to the Bar Association. And the fact that many members of the Bar Association may object to those articles is the very argument as to why Keller may apply. Because if you're annoying a large segment of the Bar Association members, such that you're concerned that they might quit the bar and protest, well, those are the same people who might be opposing being compelled to pay for speech that they don't agree with. I mean, that's the whole point of Keller, as I understand. So that's all I've got to say. I've got one other thing to say. I move that we not publish Exxon.
You move that we not
Steve?
publish Exxon? Yeah.
Not publish Exxon, yes.
Steve, this is Heidi. I wasn't I wasn't expecting Tom's motion, and I'm not going to second it at this point, but I can understand Jennifer's confusion. Where do you draw that line? Because you can't please all the people all the time, right? There might be a lot of people that don't like hot dogs or baseball. And I
That's right.
understand they're not politically charged. So there's a difference there, but these days there's very little that's not politically charged, I sense. And, how are we ever going to feel comfortable in what we're doing, without some sort of analytical scheme or, review by Catherine every single time. And I'm sure that's probably not what she wants to do. So I think we're really in a seriously murky area right now. And how we move forward from here is important. I think our journal has been a wonderful publication. It's great reading. It's interesting. And people enjoy it. I'd be curious to know how often we've gotten negative feedback on anything that's conceptually politically charged.
Colin, I think properly procedure, we ought to have a second before we debate the motion, but I'll second the motion because I think that's appropriate for debate. But much of what, as I read these things, the article that Camille's talking about, diversity and inclusion, are things that are proper for us to publish. Whether they were approved and accepted for publication or not may be a different issue. But that subject matter seems to me to be involved in regulation, and from the cases I read it, that would be an appropriate subject to discuss. And it may not please everyone, but it's still within that range of germane topics. Just like Judge Dietz wrote an article questioning the CLE system. I mean, that article probably will not be embraced by everyone, but it's about the regulation of the profession, and it seems certainly to be things that we ought to be discussing. But some things that are really don't have anything to do with the regulation of profession, even if they are very appropriate for public discussion, may not be appropriate in our journal, which we compel people to pay for, and that seems to be the thrust of Keller.
Let me ask a question about the defining what people pay for us to publish. For example, if we wanted to put something on our website, additional content that is not printed in the journal and therefore paid to be printed in the journal, can we say that nobody paid for us to publish that? Or is it just the fact that I spent time on it and I get a salary? Or 5 years ago we paid a website developer to develop our website? Like, where, can someone clarify that for me?
So Keller talked about the use of mandatory dues. The Keller court specifically declined to address the issue of just compelled association, regardless of how the dues were being spent. That is, you must be a member of the state bar in order to practice law in California. And therefore, even if you can opt out of having your dues used to fund activities with which you object, and Keller does talk about a procedure for opting out, the plaintiff in that case was arguing, I don't want to have to be a member of an organization that propounds this point of view. And even if I don't have to spend my money on it, I still object to it. The Keller court declined to address that issue. But in recent years, there have been quite a few lawsuits on that issue. That is, I don't want to be a member of an organization that takes this position, even if I'm not paying for it. And I believe that when the Supreme Court takes up this issue, it will take up this second issue of compelled association. And so whether money is spent on any particular activity is not the end of the question. It's just whether an organization that people must belong to can engage in these activities.
Well, and Jennifer, to your question about the website, that is using mandatory dues to exist. I mean, you know, it's not a direct just because of you. I mean, we can have a website because we have the maintenance and servers and all of those things that are done and paid for with mandatory dues. And so I don't know that it's, you know, anything that we put out there is out there because we, you know, from mandatory dues, because that's how we can pay for it to exist. So it's hard to separate that. You know, anything that we do is probably done via mandatory dues.
Well, for the board at the moment, there is a motion and a second on the floor concerning the publication of articles on the death penalty, or specifically Judge Exum's article. Is there any further discussion about that?
Could you restate the motion? I want to be clear how it was worded. Is it to publish or not to publish?
The motion is not, as I understand it, Tom, correct me if I'm wrong, not to publish the article from Judge Exum concerning the death penalty.
That is correct. Not NOT.
Any further discussion? All in favor of not publishing the Exum article, please indicate by saying aye.
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 Opposed?
Aye.
All right, the motion is passed. The article will not be published. I would just like to say a few things. We're past an hour. I know everybody's busy and trying to get away to the meetings in Asheville, but I'm reminded of the story of the shtetl where the people were just at one another's throats all the time and arguing, fights, and it was not a pretty picture. And all the people went to the rabbi and said, "Rabbi, please pray to the Almighty, make peace, restore to us the Yetzer Tov, the good nature of all our people." And the rabbi said, "I'll do it. I'll pray to the Almighty, and we'll restore peace to the shtetl." And he does, and lo and behold, peace is restored. The people stop feuding. There's no animosity, and everybody's getting along. But along with that, they stop procreating. They stop having festivals of joy and celebration. And so they, of course, went back to the rabbi and said, "Rabbi, please make this stop. Take away this constant serenity." And the rabbi prayed to the Almighty, and lo and behold, some amount of chaos was restored, and the shtetl was again back in the balance where it needed to be between the Yetzer Tov, the good nature of people, and the Yetzer Hara, the evil nature. So, I mean, that's kind of where I'm at. But the editorial board at this point needs to be more conscious of these obligations and times that we find ourselves in at this crossroads, while we wait on the courts to figure out what mandatory dues mean in the context of state bars being akin to labor unions. I think the board has to just have our antenna up. As Jennifer said, we've done it for years, and we've got some, and again, I think one of the things I've learned from Darren is that we should think about history and historical things, and maybe the Confederate monuments. Clearly, the Confederate monuments fall under that category, and we have a fair recital of history, and we have some conclusions in there that are not controversial. And to the extent that we can continue to do our work with the Keller antenna up and find the places where we can publish and believe that they'll be non-controversial enough to keep the state bar out of serious litigation. And that, that's a big concern of the bar, and always has been. We don't want to be involved in controversies that we don't have to be involved in. So I'd be interested in anyone else's comments about where we go from here, but I think we keep doing what we've been doing, but with a heightened sensitivity, because that's the climate we're in. And I'm open to other comments. And I don't know, Jennifer, if we want to go through what we have here. If everyone can hang in for another 20 minutes or so, we might be able to go through our list of articles.
Steve, Alice had her hand up real quick.
Yes, Alice.
Steve, I think one thing that we ought to go ahead and do in this upcoming edition of the Journal is look at our statement regarding the fact that the opinions expressed by others are not the opinions of the State Bar, et cetera. We have that. It's, and I don't know if you guys can see it, but it's in this, and I call this the masthead. I don't know what the right publication's name for it, but it's in here. It's buried. It's in little tiny print. And my suggestion is that we mirror what the Texas Bar was doing. It at least got the seal of approval from the Fifth Circuit. And to the extent that we are not being vigilant enough in reviewing our articles, it might provide some basis for defense if we were to be sued over that issue. So my suggestion is to put that on our council's shoulders, if that would be okay with the publications board, that council come up with appropriate statement, and then we work with Jennifer in finding a good location in the front end of the Journal that makes it more prominent and clear. That when we publish an article by somebody who's not a counselor or an employee of the State Bar, that it's their opinion and not the opinion of the State Bar. So I think that is something that would be beneficial for us to do at this juncture.
So are you asking that the council rewrite some of that wording, or is it just a moving?
Yeah, let Catherine just make sure that, what we're saying there is, might provide us with a basis for responding to a lawsuit that might be brought on the basis of future articles.
Because I can see moving that to the bottom of, right next to that, what you call the masthead, where it has the list of our featured articles. Those are going to be the ones that are controversial, not the rule amendments and the ethics opinions. But at the end of that, somewhere at the bottom there, right, exactly, put that statement so that as people are going down that list of articles, then they see that. And I would just say that if we're going to do that, time is of the essence, because we'll be going to press, in about 2 weeks or so. So I'm happy to move the current content there, awaiting additional feedback on how that wording should go.
Does that require a motion?
I was planning on drafting something today. I don't anticipate it being long. I think that brevity is going to be a virtue here. I was really thinking of tracking what's in that Fifth Circuit opinion. It's a one sentence thing, so.
Perfect.
I don't think that requires a motion, does it, to just make a small change like that editorially? No.
I think if you all are comfortable with us just going ahead and doing that, yeah, I just don't think you have to have a motion for that.
Okay.
So we're going to press in 2 weeks. What of the?
What are we printing?
Is this what you have listed on the agenda as the fall 2021 edition?
Exactly. And I may have room for one additional article. The Equal Access to Justice report isn't taking up quite as much room as I thought it might. So one of the other approved articles could find its way in. So I want to make sure, we've already discussed the Confederate Monuments article, and that we think that that is okay to go under Keller on our discussion here today. And I don't see anything else in here that is, terribly exciting or, political and, ideological. So I think if one of those were to make its way in, I want to make sure that we all think they're all good to go. All these other approved articles are still approved. Does anyone have a problem with any of them?
I'll just say, I haven't seen them, so my silence doesn't mean anything, but I looked on SharePoint and didn't find any content in the publications folder.
Mm-hmm.
So I haven't seen the items, so.
Yeah, those are sent. I send those to the board and to the officers.
Steve, you're muted.
Just to be clear, Jennifer, you said we're holding the Confederate Monuments article, right?
Well, based off of what Tom said, he thought that it would be fine to publish because it talks about a process.
Well, that's my opinion. I think I'd rather have my lawyer's opinion, and that's Catherine's opinion.
I'm sorry, I haven't seen the article, but
Exactly. Maybe we should hold off on the monuments. I mean, I haven't read Keller in 5 or 6 years. I don't study that sort of thing. I'd rather have Catherine's opinion, I think.
I think the monument article we should hold pending maybe a little bit editing. I agree that I think it's historical and non-controversial. Well, anyway, perhaps it needs editing, but I think we should give it more consideration by the full committee before we publish.
You would think it's non-controversial. It's non-controversial to me. I want it published. But Surrey County my county put up a monument to Confederate soldiers, I think around the year 2000. It's not on the courthouse square, but who knows? I want Catherine to look at it, frankly.
okay. I'll be happy to read the art. If y'all will send me the articles that you're contemplating, I'd be happy to read them and give you my opinion about that. I would have to do it today, though. It's not going to be possible for me to work on this during the quarterly meeting.
Have we gotten to the point where I need to copy Catherine on all submitted articles?
I think that's probably prudent.
Well,
Very good.
actually, Catherine's got a ton on her plate. Peter and I have been reading the articles. And what I suggest is it be kind of a filter. Let Peter and I read through them, and then we'll send anything we think is of concern to Catherine.
Yeah, but I think before they're approved, like maybe before they're approved, before they're all laid out, I think one of the issues that sometimes it doesn't get to us until they're already kind of way down in the process. And so if we could get to them earlier to read them, it might save you trouble and save you stress from having to go back and remove things or make changes at the end of the process.
So have Peter and Alice read this Confederate monument article?
I have not read it.
Okay.
No, I thought you were talking about the Lewis Allen story about his youth that we published already, had been published already. So I have not seen this new article.
Mark?
Steve, it'd be helpful, and maybe it'd be helpful to me specifically because I'm supposed to speak with this author next week, but it may help more broadly in terms of deciding what the ground rules are. I was asked to read a pre-publication book. It's going to be published next month by Greta Kapoor about To Drink from the Well, the struggle for racial equality at the nation's oldest public university. It's a very well-written book. She goes into the history of slavery at Chapel Hill, including things I didn't know, like the university actually leasing a bunch of slaves to serve the various students at the university, and the number of slave owners that were members, and various discriminatory treatment of of slaves and other Black people throughout the history of the university. I think it's interesting and it's historical. I guess my concern from this discussion is I don't think it directly relates to the law or legal process. It is not advocating any legislative change. It's advocating awareness of history. On the other hand, it's not really about the courts. I mean, there's some reference to the law school and some of the legal challenges to discrimination over time, but it's not really a legal process article. And so I guess my concern, and the plan was potentially to do a podcast with her and do a book review in association with publication of the book. I guess from my thinking from our discussion today and thinking about Keller is that this is not related to our core mission in terms of regulation of the legal profession or even the legal process, and therefore probably is not. And I do think people, certainly some Chapel Hill graduates, will not be pleased at the negative portrayal of the university. So it may be controversial, and I'm not sure it's a core mission. And I could see arguments that why are we using mandatory dues to attack our greatest, state school, where, by the way, I have 3 kids attended. So I'm not, I support publication, even though I'm a fan of Chapel Hill, but some people may certainly be upset. Other people will find it a fascinating story. But I guess I'd love guidance from this group, and we can do it offline or go in closed session if we need to, Catherine. But I guess I'm now torn, having read it and having thought about how we might publish on it. I'm now thinking that's probably not appropriate, as I kind of understand the revised focus on our core mission. But I'd love thoughts from other people. And again, I'm supposed to talk to her next week, so I'd love thoughts beforehand. If I need to tell her we've reviewed it, but we decided it's not appropriate, I'm willing to do that. But I don't want to spend a lot of time interviewing her and working up a podcast outline if we're then going to say it's not appropriate.
And I also have an article that I had been charged with asking someone to write, and they've reached out to me to get some more guidance. And so I would kind of like to do the same thing, know if the group's still interested. The topic was limited licensed paralegals or, limited licensed technicians. And this is not the article that we had talked about Mark writing sort of on behalf of the Regulatory Reform Study Committee, but this was the one written by the authors of the North Carolina Justice for All project. 2 of those 4 authors are now serving on the Regulatory Reform Subcommittee. But Alicia reached out to me for a little more guidance, and I was going to ask the group about that today.
Well, yours is the easy one, I think, Camille. That certainly sounds like it's germane to practice and having to do with the work of one of our committees, and I don't see where that's at all controversial. Are there other views on that?
I think there are going to be some lawyers who are going to find the topic controversial, but
oh yeah,
I mean, I don't think it's political. I don't think folks are, but I think really the idea behind the article was that they would sort of outline why they came to write this project. Why were they compelled to do the research, write the project, and then start sort of a conversation around limited licensure.
Would y'all like to go into closed session again so I can speak?
Yeah, I would move we go into closed session pursuant to the same statute that Catherine earlier referenced in order to protect the attorney-client privilege.
And that's GS 143-318.11 A3.
That's exactly the one I had in mind.
do I hear a second?
Ditto.
Can we get a second?
Second.
Okay, and we've had some discussion and advice concerning that, and I guess if we could have a motion, Mark, on the publication of that, or whether we recommend it for publication.
I guess my view, while it's well written, I do think it is not directly related to the practice of law, and I am concerned that the book concludes with a call to action for the UNC system to remedy the history of racial injustice and take action to address it, which may be controversial, but I think is a call to action that's outside the scope of, I think it's a well-pled case outside the scope of our core mission as regulating the legal profession. So I think having reviewed the book, although I think it's interesting and I commend folks that are interested to read it, I don't think it fits within our mission as a state bar. So I'm proposing that I not proceed. And I don't know that we need a motion on that, Steve, because I'm the only one that's read I'm the only one that's read the book. So, so I guess, but this discussion we've had is helpful to me in deciding what role the state bar may want to play in publishing or promoting or doing a podcast about the book. So I think I have the guidance I need.
Okay. Jennifer, do you have some idea of which article you want to plug in, given that you have a gap? I think I haven't heard any objections to the other approved articles, which.
I'm gonna have to look at the spacing on that. I will send Catherine the Confederate article as soon as we get off of this, so she can review that. If she doesn't have time, that's fine. We can say it's not necessarily timely. If everything else is good to go, then I'll just pick whatever sort of fits the space that I have.
I don't know how long the article is. It's kind of a busy day here. I don't want to give it short shrift. It sounds to me like it's something that I should review carefully.
Well, that article is not going to publish right away, so there's not a time sensitivity,
Okay.
I don't think, anymore, Kathy.
Okay.
But it would be one that if you could put your eyes on it, can help us to sort of learn where this line is. And, I think as Alice and Peter, to the extent that we can get any guidance, I think that for the time being, we should be vigilant about having staff and council give us input so that we can know where to go from here in this kind of in a limbo period, right? Before we hear from the Supremes on this broader issue. Okay.
Then I'm sort of just looking down the list of articles that everyone is working on to see what other ones might have an issue, and that would be perhaps Margaret's article on gerrymandering, even though that comes out of a bipartisan committee. They wanted to write about several bills that have been proposed. I would think that's germane to the practice of law.
Well, the standard isn't whether it's germane to the practice of law. The standard is whether it's germane to the regulation of the profession and the improvement of the quality of legal services.
Okay. And Margaret's not on the call to discuss that. Mark, you already said you have reservations about your School of Government article about the Electoral College.
I do.
Okay, so we can, I guess, strike that.
Is there a proposed, Jennifer, is there a proposed article from Margaret?
Yeah, she has been working with Mary Wills Bodie.
Okay. Yeah.
Who is on the same committee as Tom Ross, who already wrote an article that we've published out of the same committee. I think this was just a follow-up to their continued work, is my understanding. So I guess if we've published something already, shame on us, and maybe we shouldn't pursue a second article.
Well, have we seen the article from Mary?
No, she's in the process of writing it right now.
Okay. I don't know that we should toss anything aside unless, it's just obviously not going to pass muster. But I think the devil is in the details, and in many respects, what we're hearing from Catherine is, yes, germane to the practice of law, or germane to the profession, or non-controversial to the point that we can not be concerned about litigation.
Okay.
So I don't want to narrow too much what we look at. Mark?
I mean, I would just, as I look at some of the other proposed topics, the ones that jumped out at me as probably not appropriate, as I understand the guidance, would be the NASCAR, or the article about NASCAR's position on the Confederate flag. To me, doesn't appear to be germane. And I wonder about the article with statute of limitations in child sex abuse cases, whether that is going to be germane. These are just topics, so I just wanted to identify. I don't know where those may stand. I also don't know about the Justice McGee article on the LGBT case. But again, as topics, those flag would seem to me, based on our discussion, to be ones that would require careful thought about whether they are germane to the regulation of the legal profession as we've talked about it today. I don't know the details, and I know Heidi and Gray are here, but those jumped out at me as ones that might raise flags.
Yeah, the McGee case is on appeal. There was a dissent by Judge Tyson. It's in the Supreme Court right now, so that's an active case. And my law firm is also involved in that, so I can't participate in any discussion about it.
Again, I'm just confused. I just go an opinion on a case, talking about an opinion on a case. I just go, it's not germane to the practice of law, but it does have to do with the law and with lawyers and lawyering. And so that's permissible.
My take on it, again, I know it's confusing. I mean, I think where I'm coming down is we don't want to, unless it is anything that tries to state an opinion or advocate a position or tend to take a position that does not relate directly to the regulation of the profession is probably problematic. So even if it takes a position on how a case should be decided, or on how NASCAR should be the Confederate flag, or on how UNC should treat, minority students, those are all positions, and we don't want to be taking positions unless it is in our core area, meaning related to the rules of professional conduct, professionalism in the practice, and other narrow areas. We can have controversial things, but otherwise everything should basically be fairly innocuous, hopefully interesting, but innocuous human interest stories that are not advocating any position or change in the law or change in policy. And under the theory that dues paying members, might object to having their dues be used to promote, any position. So we need to really have position pieces. I do think the confusion in part comes where we have these human interest stories, but I don't think they're taking a position, right? The hot dogs and baseball is a fun story, or some of the other ones, the Mrs. Castine story is a fun human nature story, but it's not advocating any change, any legislative change, any policy change. It's an interesting human interest story that I don't see running afoul, of the decisions. But if we are viewed as advocating some change, and I think some of these things that, do, then that's potentially more problematic. So I guess that's my distillation of right. Some of the advice we're hearing. And I do think it's a useful discussion to have, because that requires a refocus. We have a number of interesting and good human interest pieces, like the take me out to the ball game piece. And we have lawyer competence, which is core to us. And I think the equal justice and serving the public is core. So like the fall edition I think those are core areas. We just need to be thoughtful going forward, and think about some of these other topics that might be seeming to advocate some change in position. And that's frustrating, because obviously a lot of what authors want to write about is to persuade and change positions. But I think my internalization of our legal advice is shouldn't be advocating any change or position in unless it relates to regulation of the profession. So it's a pretty narrow lane.
It is a narrow lane, but I think that's exactly right, Mark, what you've described.
So somebody writing about, the result of a case, like on Andrea's LGBT case, the judge writing about the opinion in that case, that's not advocating for change. I mean, the opinion has happened. And the same with this pending litigation regarding the statute of limitations with child sex abuse cases. We're waiting for that to play out. And once it's concluded, we would write an article about that. So then that's not advocating a position, that position has already been decided. Am I correct on that?
I think so. I think if it is simply reporting on a decision or a new change in the law or other stuff, I welcome other thoughts, but I would think that's fairly safe. And obviously we haven't read these, but I think what would be different is if it were an appellate decision that someone was advocating, that needed to be adopted by the Supreme Court, or, taking some position that this decision should be adopted. That would seem to be a position piece, as opposed to simply an article about some already enacted change. I think we can report on changes in the law. I mean, my assumption is that's not going to be controversial. It's more the advocacy piece where we're saying, or really not, because I've never felt like we're saying these things. We don't want to let other people use our platform to advocate change. Right. I think that's what I'm hearing. Our platform should not be used to advocate change. We can, unless it is in our narrow lane of change in how the profession is regulated, things like CLE and the rules and all that stuff. Clearly that forum is available to us, but everything else needs to just be historic, personal interest, kind of news reporting, but not advocacy pieces.
Well, historical, but no controversial history.
Well, I think that's right. I mean, we can't let people advocate. Like, that's the book I reviewed, which again, I liked, but it is a review of racism at UNC, and then concludes that we need to do more than we're currently doing to serve minority students and make them feel welcome, and use our endowment to fund additional work to remedy the history of racism. So it is advocating change. It ends with a call for action.
If you're not reviewing the book or recommending the book, could it not just be a personal interest story of you interviewing this woman and how she found out about this topic, how she researched this topic? What did she find that, was interesting, without advocating, without including any advocation for this is what she thinks UNC should be doing? But stick more to the history and an interview with her of the history and how she came about writing this book. Maybe even how did you get it published? What was that process? Because, I think maybe a lot of attorneys think I've got a story in me, but I don't know how I would go about doing that. I mean, is there an alley we can go down without advocating the book or review?
Possibly, but I'm not really interested in doing that. And I don't want to tell the author, we can talk about the book, but we can't talk about, the last chapter or your recommendations. And, this is going to be a very censored, interview. That's not my style. I'm not willing to do that.
Okay. Then let's go ahead. If each of you would look at your proposed topics and just email the group any updates you have. And because we're already at almost 2 hours and we do not have any new articles to discuss. So I'm most interested in hearing if anybody has any ideas for some upcoming topics that we could brainstorm. Everyone's gone brain dead on me. It's been too long.
It's not a brain dead. I admit, and I know I'm new to the committee and I'll be rotating off soon anyway, but I think given our narrow mission, it's not something I'm especially excited about. So I'm not, in terms of investing more time and energy into these non-positional retrospective topics. I mean, obviously we can do it. I've enjoyed reading it, but no, I don't have any further topics, and frankly, not interested in investing a lot more time given the narrow lane that we're now operating in.
And Jennifer, I'll continue to work. I'm going to reach out to Alicia today and talk about the limited licensing piece. And I will ask her, she was asking me today about a deadline, and I'll ask her to have that to us, to me in September. And then maybe you can circulate that to the group prior to the October meeting.
Perfect. Thank you.
Mm-hmm.
Any other new topics that we need to brainstorm? Anyone have any ideas? Anything hot and interesting in the practice of law and lawyering and lawyer life?
That's not intellectually stimulating. You forgot to add that caveat.
I'll add that next time for sure. Sorry, Camille. Well, we've got some articles that have been approved. We've got some in the pipeline. We'll probably get some solicited to us over the next quarter. So I will try not to panic that everyone sort of is checked out and ready to go to lunch. Certainly, if you have any ideas, if you come across an interesting person, attend a stimulating CLE or something that you think would make for a great journal article, please keep us in mind, and always approach me even outside these meetings to see if there is an interest in a topic. We're always looking for good content. So as you go about your day, just don't forget about your State Bar Journal.
Thank you, Jennifer.
And I appreciate all of your work. I appreciate all of your time today and for rescheduling. I appreciate Catherine for attending her second editorial board meeting and for taking us into closed session for the second time ever that I'm aware of. So all in one meeting. So it's been interesting. It's been a little confusing. We will get through it. And we'll make some changes going forward, but I have faith that in Gray's word, we can keep it bold and wet going forward.
Well, I'd like to thank y'all for your patience and your allowing me to come on here and talk with you about this.
Thanks, Catherine. You're not invited to my next party.
I'm actually fun at parties.
I
I want to meet your horse.
And it can still be wet. It just can't be intellectually wet, right, Camille?
Before we adjourn, Alice, I wanted to ask you, did you suggest the formation of some group maybe to study Keller and Bar journals, or where were you going with that? It's been a while.
Steve, I've suggested to the officers that they might want to appoint a special ad hoc committee to just essentially kind of look at where we are on this issue, how it relates to what's happening with the lawsuits nationally, and what would be the wisest course of action over the next few years until we get better guidance from the Supreme Court. So I think the officers will be talking about that as we're up in Asheville this week.
Great, thank you.
And I'm sure some members of this group will be asked to serve on that if the officers decide to go forward with that suggestion.
Okay, thank you. And thank all the committee members and everyone who participated today. The meeting took a different direction than I would have guessed, but I appreciate it. Thank you all. We'll see you in Asheville.
Thanks, everybody. Look forward to seeing